What's up, everybody? As you can see from the title, more of the same in this motion that we've seen in a lot of other motions, but some new details and some additional allegations against Miss Becky, including additional documents for us to review and discuss whether or not this is unethical, this is unusual, is this what a court clerk is supposed to do, is it not what they're supposed to do? They have some comments, Murdaugh's defense team, about whether or not she can plead the fifth in this hearing. I may not agree with some of their arguments there. And then they also take more shots at Eric Bland. So while it's more of the same, there are some different and additional allegations against Miss Becky and shots at Eric Bland. We're going to break it all down today as we review the latest motion filed by Murdaugh's defense team. Hit that like button if you guys haven't already. Subscribe to our channel so that you can help drive the content that we check out and review together. So let's jump in and take a look at this motion. We're not going to read all 21 pages. I'm going to pick certain parts. We're not going to rehash a lot of the arguments they've made over and over again about, the burden of proof, what they have to prove. They disagree with the state's position. They obviously disagree with the state's motion to strike certain affidavits that they've filed. We'll touch on that stuff, but we're not going to read it in detail. We're going to skip the introduction here. It's a defendant's pre-hearing brief. So basically, they want to give this judge, a new judge, this information that they feel is correct and respond to some of the state's filings. So first, they're going to discuss what they think needs to be shown. Mr. Murdaugh does not need to show actual bias on the part of any juror to obtain a new trial. If he proves his allegation that Ms. Hill communicated with the jury about the evidence presented by the defense during his murder trial, South Carolina and federal law require that Mr. Murdaugh receive a new trial, irrespective of whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. And that is the burden with a lot of post-trial motions and a lot of appellate issues. But they're saying that because she is a court clerk, because of how improper this is, because of how damning this is coming from somebody in her position, the case law is clear. If statements were made about substance and not procedure, a new trial is absolute and must happen. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury. And in order to safeguard its protection, it is required that the jury render its verdict free from outside influence. Where there was private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. So they're saying they just have to show she talked about substance. They put all of her quotes in here about watch body language, don't believe this, comments on the defense attorneys, on the defendant testifying, things like that. And they cite a lot of case law. Again, most of it is bailiffs, right? That's the court personnel. It's not a lot of court clerks because it's very unusual for a court clerk to get involved. A lot more normal for a bailiff. And you can understand that, right? Bailiffs are supposed to be fair and impartial. They are, but they're still law enforcement, right? So they still are used to going and getting the bad guy. The court clerk really should just sit there and be impartial to both sides, do their job, say the bathroom's over there, here's where your food's going to get ordered, here's exhibit 1, 2, 3, 4, 5, put them in order. That's really all the court clerk is supposed to do. They're supposed to stay there and be impartial, and usually they do. That's why it's so unusual to have a situation like this occur. So the defense goes through, they hit a bunch of cases that point out exactly what they say. When the bailiff said the defendant's a scumbag, obviously guilty, whatever, they give examples like that over the next couple pages. To hit one of those examples, we'll read Parker, where a bailiff in a murder trial said that wicked fellow, he is guilty about the defendant. Supreme Court of Oregon said that statement did not require a new trial because it's not shown that the statement prejudiced the outcome of the trial, which is what the state is trying to argue, that if it didn't change the outcome, we shouldn't have a new trial. And nothing Miss Becky would have said changed the outcome. None of the jurors said it changed the outcome. Maybe some of them said it might have changed the outcome, whatever. But that is not a strong sentiment through the comments of the jurors, even though it seems like even though the jurors that Eric Bland represents or that are not, on Murdaugh's side, none of them are on his side probably, but are not being used by Murdaugh at this point in the argument, even they say Becky said things about the defendant, the testimony, the evidence in this case. So the Supreme Court of Oregon said, nope, no new trial. But the U.S. Supreme Court, the highest court in the land, reversed, holding that the evidence developed against the defendant shall come from the witness stand in a public courtroom where there is a full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. Because if that bailiff was on the stand and he said that defendant's guilty, first off, he can't say that. It's probably a legal conclusion. But if he said there's evidence that he did this, he did that, whatever, I saw him do this, they can say if there's bias, if there were any mistakes in that bailiff's report, if he was a law enforcement officer on the case, they have the right to cross-examine him, to pick apart what he said, find out if there's another reason why he doesn't like this defendant, rather than just the facts of the case. They were not allowed to do any of that. Therefore, the Supreme Court said, we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. The state also argued the bailiff's statement was harmless because 10 members of the jury never heard his statement, and Oregon law at the time allowed a guilty verdict by 10 affirmative votes out of 12 jurors. Supreme Court rejected that reasoning, and after questioning whether the factual record supported that argument, stated that in any event, the petitioner is entitled to be tried by 12, not 9 or even 10 impartial and unprejudiced jurors. That reasoning accords with the reasoning in Cameron, again, which are other cases that they cited. So this is an example of some of the cases cited by the defense. Then they say the state misstates the controlling legal standard and provides no authority supporting its mistaken proposition. Then they go through the cases that the state cites, and they say they differentiate each one, which is exactly what you're supposed to do in a motion. Factually, legally, they differentiate each case, whether it was juror misconduct by the jurors themselves, not a court personnel, or whether what the bailiff said was actually procedural versus substantive, which is very different than what we have in this case. So they go through, they differentiate. We've read that stuff before already. We don't need to go through it all again. This is probably just for the court's edification so they can read it and understand what the arguments are that Murdaugh is making. Next, they talk about how the applicable standard of proof is preponderance of the evidence. And they go through, that's what the case law said, 2 showings by a preponderance of the evidence, extrajudicial contact or communication between jurors and unauthorized persons occurred, and the contact or communication pertained to a matter before the jury, meaning the evidence, the testimony, the closing arguments by the defense attorneys. That's the type of stuff they're talking about that they say Miss Becky said to the jurors in this case. And they say they have to prove that by a preponderance of the evidence. That's the burden of proof in the case, not, of course, beyond a reasonable doubt. The court must hold an evidentiary hearing. We've heard this over and over again. It seems like that's the way that this is tracking. So that's kind of a moot point. The state's motion to strike should be denied. State wants to strike affidavits. They say, we agree it's hearsay. The point was for the affidavits to provide the court information that they believe the jurors will testify to. If there's an evidentiary hearing, this will be a moot point. The jurors will, in fact, testify. If they don't say what was in the affidavits don't matter. If they do say what was in the affidavits don't matter, because now we have the juror testimony under oath in the evidentiary hearing. Where was he? All right. All right. So then they throw this in there. Her credibility, because the state doesn't want to talk about Becky Hill's credibility. They say this stuff cumulative. It's irrelevant. They said her credibility, the defense says, is the crux of the matter before the court. I kind of agree. The purpose of the evidentiary hearing is to allow the court to decide whether it believes the word of Miss Hill more than it believes the sworn testimony of one or more jurors. Anything that impeaches Miss Hill is relevant. So it's basically a she said, they said situation here. And the state's rhetoric about Miss Hill being a dedicated public servant, unfairly maligned, has not aged well in the 2 months since the state filed its response, to put it mildly. Miss Hill is alleged to have stolen money, illegally sold access to the courthouse, conspired with her son to conduct illegal wiretaps, and even her book has been removed from publication because of her plagiarism. Yikes. That's why we've broken down each of these things as they have come out, because they hammer Miss Hill's credibility, and it's her statement denying all these allegations versus the ethics complaints, the plagiarism allegations, the comments by the jurors, the comments by Murdaugh's team. And right now it's really stacking up against her and not looking good for Miss Hill. And again, I told you, every single one of these things that happened would be fodder for the defense attorneys to throw at her in this evidentiary hearing. And that's exactly what they did in this basically one sentence here They hammered Miss Hill's credibility. That's what I expect them to do in the hearing. And I do think it's a fair subject of discussion and argument. Personally, let me know in the comments if you disagree. Okay. To prevail, Mr. Murdaugh must prove by preponderance of the evidence that Ms. Hill made statements to at least one deliberating juror about the merits of the evidence presented at trial. We read the Parker case above. They go through more cases, again, that they believe supports this proposition. We've read a bunch of those together already. But I do want to go to the bottom of page 14 because, again, here is a new allegation. For example, emails released to journalists in response to FOIA requests show that Ms. Hill was sending emails directly to prosecutors and law enforcement witnesses for the state during trial about the merits of testimony from defense witnesses under examination at that moment. And they attach emails from Fitz News. From Fitz News. So guess what? Let's take a look at those emails. We've got them here. Exhibit A. Emails from Becky Hill to Creighton Waters, C. Jewel, G. Gent, February 21st, 2023. So this is from Andy Gibbs. This is his email address. To courthouse, clerk of court, Colleton County. That's Miss Hill. Subject matter, Murdaugh trial. For Creighton Waters. Forensic research witness is ignoring the standard crouching, stalking posture of 6'3" person would use to quietly approach the target. His assumption assumes someone simply walking up to the target on cross, ask what weight the 300 blackout would be if stalking a target. Then this is forwarded from Becky Hill, rhill@colletoncounty.org, to Creighton Waters, Carly Jewell, and Charles Gent. So Becky Hill gets this email. She forwards it along to Creighton Waters. This is somebody trying to help, the internet sleuths, Reddit, all that stuff we're talking about in the Maya case. Somebody's trying to help the AG's office pick apart defense witnesses. This person can write in. That's their prerogative, and Becky Hill can get this email. But to forward it along to the prosecution shows such horrible, horrible partiality on her part. This cannot be. We cannot have clerks of court doing this. I don't know what all of the emails were. Were there some good for Murdaugh that she sent to his team? I doubt it. But that's why the clerk of court should not be the gatekeeper of what emails go through to what lawyers. Here are her options ethically and morally, in my opinion. The best and number one thing she should have done is gone to the judge and said, Judge, here are some emails that I got privately. And then ask the judge, what should I do? The judge could say nothing. The judge could say, in my opinion, some fair answers would be provide that person Creighton Waters' email. If they want to email Creighton Waters directly, they can. If Creighton Waters wants to read it, he can. But if she's going to produce or forward this email along, I think the judge would have instructed her, and the only fair way to do it would have been to forward every email about the Murdaugh trial to both the prosecution and the defense. So they are all getting these emails at the same time. There's no bias. There's no prejudice. There's no one-upping one side versus the other, providing certain information to one lawyer and not the other. Just like it would be inappropriate for Becky Hill to call Creighton Waters and say, you need to do this, you need to do that. I heard the jury talking about this. I heard a witness say that. I think this would help. Or doing it to the defense, calling Murdaugh's team, trying to help them. Totally inappropriate for a clerk of court. Not inappropriate for a member of society. They can do that if they want to. Next is an email from Mike Logren to clerk of court, defense witness Mike Sutton. I am a former paratrooper, qualified U.S. Army veteran, and left the service at a rank of captain. I regularly shoot AR-15 style rifles and have assembled them, built them, changed barrels and calibers, handguns, and components. This sounds like emails I get all the time, by the way. It's pretty funny. It's like people watching this stuff. This is exactly how they email in. I am very familiar both with the weapon platform as well as ballistics as I reload my own ammunition for AR-15 calibers. This witness's testimony that the shooter had to be 5'2" to 5'4" is frankly pathetic, which is the argument a lot of people thought should be made and was made very verbosely and in a hyperbolic way by the prosecution. He ignores the possibility slash probability that the shooter was either on one knee or standing, but in a crouched position with his knees bent significantly. It is very likely an attacker would have been crouched low to conceal their presence, at least at the start of the killings. He also ignores that the actual rifle could have been anywhere from a 7-inch to 24-inch barrel, and if it was outfitted with a collapsible stock, all of his assumptions would have to change. I am hopeful you are ready to rebut the assertions as I find them laughable. Very clearly, obviously, trying to help cross-examination of a defense witness. And what happens to this email? Well, Becky Hill, from her email address, sends it to Carly Jewell at South Carolina AG's office.gov. Here's another one, she says. Did she ask Judge Newman about this? I don't know. I would be shocked if Judge Newman said, because whatever you think about Judge Newman, there's no way he was doing stuff. I shouldn't say that. I don't think he was doing stuff like this saying, yeah, send it along to the prosecution. He would say, not your job to forward it along, or provide them with the AG's office email. If they want to send it directly to them, it's theirs, or send it to everybody. Make it part of the record if we need to do that. But there's almost no way anybody should be okay. Anybody in the judicial system should be okay with her forwarding these emails along just to the prosecutor. How else can this be looked at or defined but trying to help them? I mean, I'm surprised Creighton Waters didn't respond being like, hey, don't send us this stuff, Becky. That's what I would do. I'd be like, do not send me this stuff, please. A, I don't need it. We already know this stuff. We have our experts. And B, this is improper. All right, let's get back to the motion. All right. It is possible that Ms. Hill will respond to one or more questions at the evidentiary hearing by asserting her Fifth Amendment right. Okay, we knew this was coming. They have something to say about her asserting her Fifth Amendment right. She should not be permitted to do so. She waived the right to assert the Fifth Amendment in this proceeding when she submitted an affidavit specifically denying each allegation against her. So I disagree with them. I understand their argument that you're not, as a criminal defendant or as a person, allowed to say certain things and then refuse to answer questions about those things. I agree with them there. But I think the court has options, and they do bring them up later. And I think the court either should strike and completely ignore her affidavit that she sent denying all these allegations. If in fact she wants to plead the Fifth, then her affidavit should be struck. It should not be considered by the court. And any question she pleads the Fifth to, because she's not in a criminal defendant proceeding, it's almost more like a civil proceeding. I think the defense would have the right to a negative inference based on those questions, meaning, did you talk to a juror about this case? I plead the Fifth. They should be able to then argue to the court to infer that the answer to that question is yes, because if her answer is no, she wouldn't be incriminating herself. And while you can't use that in a criminal proceeding to convict them of that crime, you can use it in certain civil proceedings. You can use that negative inference, which is why pleading the Fifth is not always bad if you're the lawyer asking the questions. And if that's how it works, a lot of time we'd like to ask a ton of questions, let them plead the Fifth to everything, so we get to use that inference on all of those answers. They cite a case that says, holding if a witness offers testimony voluntarily, his credibility may be impeached and his testimony assailed like that of any other witness, and the breadth of his waiver is determined by the scope of the relevant cross-examination. If she asserts the Fifth Amendment in response to any question, she should be instructed to answer the question, and if she refuses, her testimony should be struck in its entirety. Not just her testimony, but I think her affidavit. And maybe they're including her affidavit in that. Okay, let's jump to page 16 here. The state has had months in which to use the tools available to law enforcement to conduct discovery regarding this motion, as well as to investigate the numerous independent complaints of the wrongdoing against Ms. Hill. Again, because we know there's a lot of ethics complaints and plagiarism and whatever in her son's case. it will be, and by the way, if you remember in a press conference, the defense said, we don't know anything about that. We don't know if there's a connection. Well, now they're putting in court documents that they believe there is a connection. It will be well prepared to bolster its witnesses and to impeach witnesses favorable to the defense. Mr. Murdaugh has been unable to conduct any discovery whatsoever. All he has are voluntary statements made by jurors and other witnesses willing to talk to his lawyers and information published by journalists like Fitz News. To be prepared to go forward on the January 29th date set for the evidentiary hearing, he urgently needs the state to produce this discovery and to receive authorization to issue his own subpoenas as soon as possible. So they're saying, Judge, it's unfair. The state has all this information and they're not giving it to Mr. Murdaugh. We need that information. I think they're right. I think that information should be fair game. I think both sides should go in with open eyes and not have one side hide the ball. Jurors and Judge Newman, if necessary, should be examined in camera by the court, but other witnesses should be examined by counsel in open court. The default method of examining witnesses at an adversarial proceeding is through questioning by counsel for the parties. All witnesses should be so examined unless there is good cause to reserve examination to the court. Mr. Murdaugh believes good cause exists for the court to conduct the examination of the jurors, including dismissed jurors and alternate juror itself in camera with a redacted transcript to provided to the public. For their protection, for their privacy. That's how we've seen interactions with jurors in the past, just like the Take Care of Maya case. The court does the questioning. In addition to asking its own question, the court should accept suggested questions from the parties in advance of the examination and during the examination, which the court, in its discretion, may or may not ask. Exactly what we saw in the Maya juror interview. In addition to shielding jurors from appearing on television involuntarily, in-camera examination is necessary because it will be difficult for a juror to testify without revealing personally identifying information like his or her name or the names of other jurors. They're trying to protect the jurors here, unlike what happened in Maya. By testifying in camera, jurors may speak freely with any personal information in their testimony redacted from the publicly available transcript. Further, jurors may be unsettled by being interrogated by the same lawyers they watch interrogate witnesses for 6 weeks. Examination by the court avoids that issue. I agree with everything in that argument. The state agrees jurors should be examined by the court and has argued the court should question them with a mind to at least whether the communication actually occurred, and if so, the context and substance, the number of jurors exposed to the improper communication, which the defense has argued doesn't matter. Even one is too many. The weight of the evidence properly before the jury, and the likelihood that cumulative measures were effective in reducing the prejudice. Only the first topic is appropriate. The only relevant subject matter for juror examination is whether Ms. Hill made improper communications. Again, we've already read those arguments. If testimony is needed from Judge Newman, Mr. Murdaugh believes it should also be conducted by the court in camera to preserve the dignity of his judicial office. We got to appreciate that, right? Mr. Murdaugh does not believe good cause exists to examine any other witnesses for the court to examine them in camera, including Ms. Hill in any fashion other than the traditional means of attorney questioning in open court. Ms. Hill especially is an elected public official accused of malfeasance in office, who Mr. Murdaugh is accused of violating his constitutional rights in a criminal proceeding, and who has voluntarily provided an affidavit directly contradicting Mr. Murdaugh's claims, which is why we didn't know if she was going to comment. We didn't know if she was going to make a statement. And by doing so, she's opened the door to a lot of things. She does not need to be shielded from the scrutiny in the same manner as anonymous jurors involuntarily summoned to serve. I kind of agree with them here. She is a witness against Mr. Murdaugh in a criminal case whom Mr. Murdaugh has a right to challenge in open court. I agree with him. You guys let me know if you disagree. Here we go. I talked about shots coming at Eric Bland. Well, here they are. Attorney Eric Bland has requested to participate in these proceedings as counsel for certain jurors who may be called to testify as witnesses. Mr. Murdaugh objects to Mr. Bland's request. This is a criminal proceeding brought by the state against the defendant. Mr. Bland seeks a level of non-party participation, example, participating in the status conference, beyond even the rights afforded to victims under Article 1, Section 24 of the South Carolina Constitution. And the jurors he represents are not crime victims. I agree. In discussing his request in the media, Mr. Bland stated on his podcast, Cup of Justice, that Justice Toll, the newly assigned presiding judge in this matter, has friends sometimes to reward and enemies to punish. Yikes. Did he really say that? And I worry about what procedures are going to be put in place. The fact that there was a status conference, and I represent 4 jurors. I wasn't even told of the status conference. And I believe that my jurors, that's interesting language, have the right to legal representation in any type of proceeding dealing with Alec Murdaugh's verdicts where they're going to have their verdicts questioned. I wonder if I should try to listen to that. Did he actually say that about Judge Toll? That would not be a great start. But I disagree with Mr. Bland here. He represents these jurors. It's very important. He should be able to object to certain questions. He should be able to file motions for protective order. Usually he would, no witnesses to any trial I've ever really had have been part of status conferences or scheduling. What they can do if like their witness or a juror is subpoenaed on a date they're unavailable, again, they can file a motion for protective order saying, Judge, we're unavailable. We need to do it on a different date. We need to do it by Zoom, whatever it may be. They have certain rights, but it's not the same rights as the parties involved. His stated intent is not to protect the personal interest of his clients as witnesses, but to advocate to sustain their verdict, to allow a publicity-seeking lawyer for non-victim private parties to intervene in this criminal case and advocate against Mr. Murdaugh as an additional opposing party would violate Mr. Murdaugh's procedural due process rights under Article 1, Section 3 of the South Carolina Constitution and the 14th Amendment of the United States Constitution. Yikes. Shots fired. I do like how once in a while they're like, they have very fine counsel. These are some of the best lawyers in South Carolina has ever produced. They throw those compliments to each other that are absolutely backhanded because they take so many shots at each other. It's just kind of part of the game at this point. I'm sure Eric Bland takes no offense and expects this stuff, just like Murdaugh's team expects it coming back from Eric Bland. The jurors are simply witnesses with no more right to participate in this proceeding than witnesses in any other criminal case. Unlike typical witnesses, they do have a right to a degree of anonymity, so it could be appropriate to allow them to be heard through counsel if the court were inclined to strip them of that anonymity. But neither party is asking the court to do that, and the court has made clear it is not inclined to do that. I think it's better to do it in camera like they asked for, and it seems like the AG's office also agrees with. Mr. Murdaugh does not seek to subpoena telephone records or other personal records regarding them. And if he decided to do so in the future, their lawyers, of course, could file a motion to quash. Absolutely. We've seen other cases where they've tried to do that to jurors. Otherwise, they would have no cognizable interest in these proceedings. And if there is such an interest, the Attorney General would be adequate to assert it. Makes sense. The reason to hold an evidentiary hearing on defendant's motion for new trial is to protect Mr. Murdaugh's constitutional right to a fair judicial proceeding. It would defeat the purpose if the proceeding were allowed to devolve into a speaker's corner for lawyers who want to appear on television even more than they already do. I do think that they had their moment in the sentencing. The lawyers did a really great job, including Eric Bland, of hammering Alec Murdaugh where it was appropriate. This is not that type of hearing. It's not that kind of party, people say, right? This is not that kind of party, in my opinion. Mr. Murdaugh therefore asked the court to limit the participation of any witness retained lawyer to the extremely limited role traditionally allowed to a lawyer representing an innocent bystander witness in a criminal case. Right. If something crazy happens, they can object. They can tell their witness to stop testifying. They could say, we need to meet with our client, stop the testimony, discuss pleading the fifth potentially. That stuff potentially would be allowable. But the stuff they're asking for usually is not. Further, he requests that the court order the clerk of court not to accept any filings in this matter from any non-parties without leave of court obtained prior to filing. So don't allow Eric Bland to file anything unless they get leave of court, which is normal if an attorney for a witness wanted to file something. Motion to intervene, things like that, like we've seen the media do in other cases. For the foregoing reasons, Murdaugh respectfully submits that when Ms. Hill's jury tampering is proven at the evidentiary hearing, the court must grant the motion for new trial. Whew. A lot there. A lot of shots fired at Ms. Hill and Mr. Bland. Not that surprising, but honestly, those new emails that we're seeing forwarded along by Ms. Hill is just more evidence of wrongdoing. I don't see how this verdict is maintained based on her actions. Regardless of what you want to say about any of the lawyers, parties, jurors involved, she just did too much. And the next clerk of court should just do less. Let the AG's office present the evidence, and the chips will fall as they may. That's how the judicial system works. This just brings more questions rather than answers to our judicial system. I don't love to see it. But I can't wait to see your questions and comments and what you think about this new information and some old repetitive information. What do you think is going to happen? A couple weeks from now, we're going to have this evidentiary hearing. Will the AG's office turn over all the discovery they have? we will, of course, continue to follow it and discuss it together. I appreciate you guys joining me. As always, until next time, I'm out of here. Hit that like button. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a uase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.